Hey, everybody, welcome back to Jersey First TV and the Nader narrative. There's a lot happening in the news right now, a lot of distractions, a lot of drama, so much going on. And while that's all happening, did you realize what the Biden administration was up to? Are you recognizing some potential overreach and some rules and regulations that maybe isn't in their purview to establish? Things that will change potentially the way you experience your job, and to business owners and to corporations, the way that they operate. These are all things that we need to understand, and they're sort of happening while the rest of us are focused, sadly, on a lot of other drama situations. So we need to know what's going on in DC. We need to understand how this affects the economy, how it affects all of us. And to do that, we're going to bring our two really smart people back with us. I am pleased to have with us today Douglas Holtz-Eakin with us, and as well as Rosemary Becchi. Now, you guys have seen Doug before. He's an economist and, of course, a former CBO director, which makes him incredibly intelligent and able to talk about all of these things. And Rosemary, of course, is our founder of Jersey First, tax lawyer, and one of the co-authors of the 529 bill. Rosemary, thank you for that. A parent of 4 teenagers. I appreciate that, Rosemary. But let's get into this a little bit. Doug, I'm going to start with you. I'm sort of titling this show, Is the Biden administration overreaching and overregulating businesses? Now, I think that show could go on because there are a lot of things that are happening in DC, but we're going to focus on 3 issues that I think the public needs to understand. And I want to start with something that's happening in the FTC, and it has to do primarily with non-competes and basically banning non-competes. Tell us what they're talking about.
Well, before I do that, let me just give you the really big picture. One of the things we do try to do is keep track of the overall regulatory activity of the administration. And to date, it has imposed 551 final rules, which impose a cost of $360 billion on the private sector. So that's like having $180 billion a year tax increase, and an additional $220 million in paperwork hours. So the answer in advance to your question, are they really active on the regulation front? Absolutely. More active than Barack Obama was at this point in time. Just a remarkable pace and cost. On the non-competes, these have been around for a long time. And they say that over a particular time period, say a year or two after you leave a job, and in a particular region, so maybe in your states or in the neighboring states, you can't take a job with a competitor and thus compete with your original employer. And it made sense if you had someone who had developed a trade secret, had a formula or a patent or something, that they wouldn't take that, which the company had paid for, and walk away with it and use it to compete with them and put them out of business. So they've been around for a long time. There do appear to be legitimate uses of them, and we've studied that. But there is this assertion by the FTC chair, Lina Khan, that they are now widespread in the economy, that an enormous fraction of our workers are chained to their job and cannot leave one sandwich shop to go work for another, and things like that. And so they are seeking to ban these non-compete agreements across the board, every state, every industry, every worker. And that is a dramatic regulatory move, and really raises 2 questions. Number one, always, does this make sense? Is this something you would want to do? Number 2, is the FTC allowed to just do this, or is this something that maybe the Congress ought to be doing?
Right. A lot we can unpack there. Let's start to unpack it, but let's first hear directly from the FTC chair, Lina Khan, to see how she is positioning this in the media.
So non-compete clauses today govern around 1 in 5 U.S. workers. These clauses may have started in the boardroom, but today what we see is that they've proliferated across sectors and across income levels. So we're talking about nurses, we're talking about fast food workers, janitors, but also physicians and engineers. And we've now seen that in the aggregate, these clauses can really restrict competition, both in labor markets, but also in product markets. And so our economists calculated that collectively American workers are earning around $300 billion less because of these non-competes, and that on the whole, innovation and entrepreneurship are suffering.
Okay, so Rosemary, first of all, she presents this as though it's become a scourge upon the upon the business community, employers throughout the nation. Doug made a good point. Is it really as widespread, these non-competes, as she would claim?
Look, these non-competes actually help competition, and they actually are there to help both employees and employers. I don't think they're as rampant as she suggests. I do think that they are being used, as I said before, to protect employers, right? You don't want somebody that's got confidential information walking across the street to your competitor and taking that information and potentially putting you out of business. On the same side, it also actually protects employees and helps employees with mobility, job training, right? If those non-competes are put in place and people go to a competitor, that there are restrictions there that don't allow them to take that. And in fact, a new employee or a new employer might be more likely to invest in an employee, that is subject to those types of arrangements.
Right. So it's interesting, Doug, they claim it's something that will help the economy. And this is the thing that a little bit of the strange messaging we've been getting in the past few years about, no, if we spend X billion of dollars, it helps the economy. If we put in this regulation, it will help. I'm struggling with that, Doug. Can you give us a little insight into their mindset?
Well, they have a particular view of the universe that says that companies don't count, shareholders who own those companies don't count, entrepreneurs who started those companies don't count. All it counts is the workers, and they count especially if they're unionized. And so when they say it's going to be good for the economy, they have a very narrow view of what that means. It's not good for the citizenship as a whole. And I just want to emphasize something Rosemary said. It's really important. These can be very beneficial to the worker. I mean, if you have the knowledge of the non-compete, you are willing to invest something in the worker, knowing they can't walk out of the firm with that valuable investment. And so they end up in a better paying job and with better skills. It's also true that if I took a job where I know I'm going to have to sign a non-compete agreement, I might make them pay me more because they're limiting my post employment opportunities. So there's no real evidence that this has somehow mucked up the labor market. People take jobs, they depart jobs, firms find workers, and the non-competes do not appear to be anything like what she described.
Doug makes a good point, Rosemary. There's often consideration given in return for non-compete and also an NDA, a non-disclosure agreement. They're sweeping this into this regulation as well. And Rosemary, as an attorney, what kind of damage can that do? I mean, now I just want everyone to consider that we would have companies operating with no non-disclosure agreements, with no non-competes. Where do we protect intellectual property? Where do we protect, means and ways of operating a business? And how does this ultimately hurt everyone?
No, absolutely. I mean, the way this rule is drafted, it is so broad that, just as you suggested, it does sweep in all those arrangements, the NDAs and other types of arrangements. And again, that isn't helpful to anyone. It doesn't help anyone when somebody takes trade secrets and walks across the street and gives it to a competitor. Now you've created unfair competition, right? In many instances, these agreements actually foster fair competition. And I think that's what the FTC is missing here.
Doug, talk to us about the regulatory environment. You brought it up in the beginning.
Right.
Is this legal? I don't even know if I'm using that word. Is it correctly? Is this something that just with a stroke of the pen, that's it, it's done? Tell us precedents, and also, is this actually going to go in place?
This is an incredibly broad rulemaking, as Rosemary said, and there's reason to be nervous about that. The FTC typically promotes competition by finding specific actions by firms or workers and judging those and finding people and getting remedy where necessary. Very targeted, very focused. This is an economy-wide sweeping rulemaking, and the FTC has a history of overstepping its rulemaking authority and then having the Congress essentially pass legislation to clip their wings. this sure feels like another episode of that type. It does come on the heels of a very important decision by the Supreme Court, where they ruled on what's known as the major questions doctrine, West Virginia versus the EPA. There are some things that an agency, the FTC, the EPA, name it, simply can't decide. It is too big an issue and is something that the Congress should decide in the legislative arena. Sure feels like, sweeping restrictions on the kinds of contracts that people can enter into is the kind of question Congress ought to be dealing with, not someone at the FTC.
Right. So, Rosemary, this is the age-old question of where does this belong? How do we as citizens look at this? Where are we at right now? Do we call our congressman and say, hey, you guys need to do something about this? Is Congress going to step in? Is this happening? Is this a runaway train that's going to end up in the courts? Where do we stand?
No, this is absolutely has to come from the grassroots. It's so important because your regulatory bodies are making decisions that Congress should be making. It's not appropriate. It is illegal. And it's really important for people to speak up about it. I mean, it's repeatedly happening. I mean, you alluded to it in other instances, like with the whole worker classification and independent contractor. I mean, that also impacts every single worker in this country. And these aren't decisions that a regulator should be making. These are decisions that belong to be made by Congress.
And I wonder if any of these regulators have actually ever owned a business. I would start with that, and ever tried to protect, right, any intellectual property or ways of doing business. Doug, we have some precedents recently with wasn't it OSHA that tried to force the vaccine requirement, and that became an issue of law of whether or not they had the right to do it. Again, a body that has regulatory power overstepping and saying, no, this isn't our purview, and the court saying, no, it's not. Do you think we end up in court with this?
I think we end up in court with this inevitably. It's a major restriction on both sides of these agreements. These are agreements. People both agree and sign these non-compete agreements. And for the FTC to just jump in the middle of a private agreement of that sort is really inappropriate. So I think there are lots of parties that will have standing to sue. They will sue and contest the rule. It'll probably end up at the Supreme Court. And I think given the way the court has steadily trimmed back the deference to agencies in their rulemaking, this is another place where we'll get trimmed back and they'll say, no, you need to go through Congress and get something like this done. And if you can't get through the House and the Senate, then it shouldn't be the law of the land.
The other thing, Elizabeth, I'll raise too, is what the FTC is proposing here is to make the every single non-compete in existence void.
Yes.
So it would actually be retroactive.
Right.
So you're talking again, as Doug pointed out, you're talking about people that have entered into a contract, right, on their own volition, arm's length negotiations, and suddenly they're going to wake up and it's void.
That by itself is just inconceivable. I don't know what they're thinking.
Well, Doug, it's inconceivable, but the question that often doesn't get asked is, who started this? Where did this start from? Why is this partisan? Because it appears to be, right? And who is calling for this? Who just woke up one day and said, you know what? I need to do something. I'm bored here at the FTC. Let's mess with non-competes and NDAs throughout this country at every level of business. Doug, where's this stemming from?
Honestly, I don't know. This FTC is unlike any other we've lived with, certainly in my lifetime. Lena Khan has a very personal agenda that she brought to the FTC, and the administration has a very union-driven set of issues that has a lot to do with how they got elected. And so there's a perception that you just don't want to have things that the unions don't approve of, and that the Lena Khan in particular is willing to take on. So I don't see a real deep philosophy at play here. I mean, this is politics. We can win on this playing field. Let's go do it.
Yeah, well, we didn't elect Lena, but apparently that doesn't matter. Let's look at another thing they're trying to do. I'm just going to play a little bit of what's going on in the gig economy.
Proposed a new rule that will make it more likely for millions of gig economy workers to be classified as employees. Uber and Lyft and DoorDash all trading lower on this news. Yahoo Finance's Brooke DePalma sticking around with us for this conversation. Brooke?
That's right. So this new labor law will allow protection of workers' basic rights, make it easier for employers to properly classify their workers, and also protect independent businesses that follow the law. Of course, that's out from the U.S. Department of Labor this morning. Companies now expected to provide certain benefits to full-time employees and not to contractors. Of course, that includes minimum wage, overtime, a portion of workers' Social Security taxes, and contributions to unemployment insurance. But here in a tweet from U.S. Secretary, he says that misclassification hurts workers by denying them important benefits and basic rights like that minimum wage and overtime pay. It's a problem we often see in low-wage jobs. Enforcing the rights of misclassified workers is a priority because these workers have so much at stake. Of course, this comes on the heels of the Supreme Court overturning Roe v. Wade in earlier this summer. And it also comes after 25 Democratic members of Congress, led by Elizabeth Warren, Representative Bush, Cory Bush, it is in Missouri, sent letters to the CEO of Amazon, Lyft, DoorDash, and Grubhub to question a policy that was a Trump-era decision. Now, of course, Wall Street reacting to this, shares lower on.
Okay, well, I don't know what that has to do with Roe v. Wade. I always find that somewhat amusing. We got a lot of that this summer. I mean, there were so many things. Roe v. Wade is the most powerful decision, I guess, ever brought down upon mankind because it affects everything. Rosemary, this is misclassification. This whole, in fact, it's interesting. The words that are used here it's very much not reporting. It makes it sound like this is the best thing we've ever done to protect the working class. This is really about 1099 workers. And there are many people listening right now who are 1099 workers, who are able to be flexible, take on multiple jobs, not be in full-time employment. But the way the administration makes it sound, we are abusing these people. So let's talk about how this affects businesses as well, because I got to tell you, these businesses are starting to choke as we're watching this, right? How does this hurt businesses, Rosemary?
Yeah, it absolutely hurts businesses, and more importantly, it hurts workers. People make a choice to be an independent contractor. It provides them with the flexibility that they need for their lifestyle. It also allows people to become entrepreneurs and to really build their own businesses. And many people choose to do that. So it's really actually overall hurting our economy.
Well, not only that, but Doug, I'm imagining now, maybe not 87,000 agents as they had hoped to bring into this world this year, but this is all about now really going after the businesses and saying, let me see let me see who you've paid. You've misclassified. This needs to be a full-time individual. What kind of cost is this to companies?
So I think the important cost is actually going to be on the workers. So if you think about this, we're going to snap our fingers and say this person is an employee, no longer an independent contractor. They are now eligible for this array of benefits, minimum wages and overtime, and Social Security taxes get paid, and unemployment insurance compensation payments get paid. That makes that employee much more expensive. Given the original revenue of that firm, not all of those employees are going to survive. We're going to see many of them laid off because there is no more money. You snap your fingers and classify them. It doesn't make the firm more profitable. It doesn't give them the money to do this. And so in the end, you're saying, we would like to get rid of some employees. Let's just, pass this and they'll go away. That can't be good news for them. And as Rosemary said, if you actually poll the independent contractors, they prefer their status by a vast majority because it gives them the flexibility they want. So this isn't in their interests, and it won't lead to better employment for them. It'll hurt them in the end. Businesses will do what they have to do. They will try to accommodate an additional cost that the government's imposed on them, try to make a decent product and service and deliver it at a reasonable cost. But they're just running into a headwind that they can't avoid. And so it's a really bad news story from both the worker and the business point of view.
One of the beauties of our economy has been the ability for people to sort of create the life they want. And Rosemary, you spoke to that. And especially, in this recession and the difficulty many have of making ends meet, the flexibility of just taking a Lyft job. I think Lyft and Uber are such good examples, right? Just for a month in order to create enough income to pay some bills. I mean, there's so many people that need that flexibility. There are independent contractors. I'll give you an example, Rosemary, like a photographer for weddings who gets hired. How does this affect them? I mean, we're not thinking through the impact on the beauty of our economy, which are gig workers. It's actually an advantage we have, isn't it, Rosemary?
No, it absolutely is. And frankly, I think that this is a women's issue. You know, a lot of women who have children need that flexibility in order to, earn income, but aren't able to be at a job from 9 to 5. So a lot of times, they're able to do freelance work or things of that nature, just as you suggested, driving for Uber or Lyft or other means. There's almost every single industry has a need for the independent contractor role. So it will greatly hurt workers in this country.
The messaging from the administration continues to be that we're protecting the workers. I think the Americans are getting smarter. As long as they're aware of it and they hear we're protecting you, I think they should immediately wonder, Doug, whether or not that's true. It seems to be quite the opposite, doesn't it?
Yeah, goes back to the old Ronald Reagan line that the worst words you ever want to hear. I'm from the government. I'm here to help.
That's right.
Be nervous about that.
Right.
It's important to recognize that the language is, I think, borderline deceptive here. They're saying the workers are misclassified. That's not actually what this does. It says we are going to change classification rules, and we are going to move them by the rule into a different classification. It's not that some mistake has been made or they've been taken advantage of. It's that they want to change the rules. And that would be a more honest presentation. Last thing I'll say is California, which is a great example of how to build a better Utah, insists on doing things like this. And they took a run at this first before everyone else. And what did they do? They put all the seasonal Santa Clauses out of business. I mean, this is crazy. And they need to think about what they're up to. We have some experience with this. It didn't go well.
It's not like we don't know. And, that's from children. So, I mean, this is getting emotional now, but I mean, really, we know, we've learned and we know better. And you're right, Doug, that the messaging and the language is meant to make you think that there's a problem, that people are already breaking some sort of law or rule. One more piece of overreach before I let the two of you go, because this one is a veto by Biden. Let me just show you this very short clip and we'll talk about it.
Sign this veto because the legislation passed by the Congress would put at risk the retirement savings of individuals across the country. They couldn't take into consideration investments that wouldn't be impacted by climate, impacted by overpaying executives, and that's why I decided to veto it. It makes sense to veto it.
I love how they present that with music, a little bit of marketing behind it. But okay, so Doug, this is really about ESG. And we did a show on this with Paul Teller this summer. ESG stands for environmental, social, and governance. And it's this new way of deciding whether or not a company is investment worthy. The scary thing is we're tying this to 401ks. Explain to the people why this is an issue and why he vetoed it.
So what's interesting about the video, it's the first I've seen it, is that they don't mention the fact that what spawned the legislation was a Department of Labor rulemaking that limited the kinds of things that people could take into consideration in doing their investment planning and 401ks and things like that. A majority in the House and the Senate on a bipartisan basis decided that this rule was inappropriate and an overreach and passed legislation to get rid of it. And the president vetoed that legislation. But the original comments is on the DOL rulemaking and the idea that these ESG funds had to be part of the 401k world in a way that people might not want. So, it's a really incomplete story. This is an important tool, the Congressional Review Act. Yeah. Also not mentioned in the video is that was his first veto. His first veto was used to protect the bureaucrats at the Department of Labor. Mark that one down. And there will be more because including Democrats on Capitol Hill, they see an administration that's ignoring what they think of as their appropriate role and what they know their constituents care about. and is just moving ahead with an agenda they're trying to do just with the agencies and the rulemaking. And that's what's really at stake here.
And Elizabeth, this goes to my earlier point. It is so important for people to speak up. This was a perfect instance where both the House of Representatives and the Senate passed a resolution that says, hey, we don't agree with these rules. Right. And DOL, by the way, you've overstepped your bounds. And therefore, we want the rules pulled back. And he vetoed that. It is so important for people to speak up because it is their 401k and it is affecting their everyday lives. And you can't have bureaucrats making those decisions.
Well, we've been here before, Doug. You mentioned in the last subject about California. Let's all remember the internet boom when suddenly the rules of what is profitability went out the window. All you needed was a .com and everybody put their money in there and nobody cared if you're making money. ESG is the same thing. It should matter whether or not a company can actually turn a profit, not if they're friendly to the climate. And this directly affects the investments of so many people in this country.
And here's one more little piece of nuance to this story that I think listeners might want to know. The procedures under which they did this, the Congressional Review Act, what they say is Congress can say, no, that rule's not okay. And they did that. And then if it passes and is signed by the president, they cannot do another rulemaking in its place. So you take that area off limits forever. So what he really did was preserve their ability to keep making rules by vetoing it. So, for example, go back to the FTC and non-competes. It would not be crazy to see a Congressional Review Act say, no way, pass the House, pass the Senate. He would veto that as well, because the last thing he wants to do is to tie the hands of his FTC.
Clearly. Wow. Well, rules everywhere we look. Of course, the media is not talking about it. They're spinning it to us in general. And these affect us directly. So everyone pay attention. You've got to make calls to your Congress people. You've got to stand up. And I think this is a first step in just educating people what's going on. They're dramatically changing the way our economy works, the way businesses work. And all people who say, I don't own a business, you should care. You're an employee of a business. It all affects all of us. Rosemary, as we leave, I'll let both of you say one more thing about this and what we see in the future now that we have a Republican Congress. Are they going to be able to stop enough of this before the damage is done?
So again, I think it is very important to continue for folks to reach out, again, as you said, to their congressperson and reach out and object to some of these questionable rules. Whether or not we will be able to stop them depends, but the more noise you make, the more likely we are to be able to stop them. I definitely fear that this administration is going to continue, just as Doug suggested, on the path that it's been on and continue to put out rulemaking that harms actually workers and harms employers, and ultimately it harms our economy. So it is really important that people speak up.
Doug, one last word to everyone, please.
Let me just echo that. I think it's really important to recognize this. There's nothing more boring than talking about rulemaking. Nobody ever wanted to get out of bed and talk about rulemaking. But it turns out it's really important, and it can be really expensive. We all get ginned up about a big tax bill. We have a $360 billion disguised tax bill known as the Biden regulatory agenda. It's worth getting upset about.
Wow. Well, Doug, for you and all your experience, well, both of you really, sometimes it must just be real difficult to look at the news in the morning and see everything that's happening. But the good news is Americans are generally common sense people. So as long as we're paying attention and as long as we open our mouth and we do something about it, hopefully this pendulum will swing back to common sense, right? I thank you both so much. We'll be watching all of this. We'll have you back for an update. Appreciate you guys, and to my audience, make those calls, pay attention. This all affects you. We'll see you guys next week.